Yes, yes.
You're beautiful, Karen. I think it goes without saying you have a lot of people loving you right now, Karen.
Love you, Matt. Love you, Matt. Love you, Karen. Dale. Love you, Dale. Thank you, honey. Thank you.
Hey!
Love you, Karen. Let's go get free, Karen, free. 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 Free,
How you doing, guys? Hey, guys.
I had spoken to Trooper Proctor in regard to his communications. If they haven't been received by the clerk's office yet, then I will ensure that they are
Forthwith.
yes.
Okay. All right. And the Verizon records that were ordered, what do you know about that, Mr. Lally? Any information on that?
I don't.
Okay. Mr. McDermott, this is the one that Verizon sent the wrong records?
That's correct.
All right. And you followed up with them?
I did follow up with them, and they were going to fix the situation. I don't know if there's a cell phone record received from Verizon on January 25th, but that was probably the first one that was incorrect, correct?
It was.
Okay.
All right.
And for the record, Ms. Little did call Verizon on January 25th. As soon as we received those records, that was the first time we did receive them.
Okay. So, Ms. Little, is that what you wanted to address?
Yes, Your Honor. As you know, at the last court date, we had discussed at sidebar what the status of those records were. We did get a copy of the court order. I was able to follow up with Verizon. It looks like they were sent to the court actually back in November of last year. The date of that letter was, I believe, late November. Once we received the records, it looked like they were from the incorrect user. I was able to call the law enforcement and court number to speak with them about that.
Okay.
They did acknowledge that there was a mistake on their end, but they asked that the court clerk follow up with them because I was not an authorized person to discuss those matters.
All right.
And I know that Jim very quickly reached out to follow up with them.
Yeah.
And I did. Yeah, thank you.
All right. So we can double check that perhaps, Mr. McDermott?
I just did check. I haven't received anything yet, but I can follow up tomorrow.
All right. Great. All right. So that moves us to the DNA, Bodhi technology. Let's talk about that first. Mr. Lally, that was to be expedited. What's the information we have from them?
So that is really the only issue and the reason that it's a joint motion to continue from my perspective. I don't oppose the motion, but the reason that it's a joint request from my end. So where we stand, I spoke with someone from Bodhi yesterday.
Okay.
And really what I had said to Mr. Yannetti, but it didn't get encapsulated within the motion, is there are the two sort of different sets of testing that are going on. So there's the hair sample with the mitochondrial DNA testing, and then there's the taillight evidence with regard to the troopers' samples that they submitted as well. So with reference to both of those samples, I anticipate initially what I was told, even with the 8-week rush expedited return, was sometime around the 3rd week of March or something like that. And so that was in part why
It's a lot more than 8 weeks.
Well, it's 8 weeks from the date that they received it. So and there was some delays in regard to that as far as whether or not there was going to be any observation of testing and collecting samples, submitting the samples. So it's been a bit of an arduous process. But the point, the further point of clarity that I received yesterday is that they expect, it's not a definitive due date, but their expectation is that that testing should be completed the first week of March now, with regard to both sets.
Okay.
My issue, though, sort of ancillary to that is, and I'm not faulting counsel for this, but I have no reciprocal discovery in this case. And my expectation is that I may be receiving some, if not a voluminous amount. I can't file a certificate of compliance and a motion for reciprocal discovery under the rules, as the court is well aware, until I've completed my discovery obligations, which I won't be able to do until we get to that first week of March when I get the DNA reports. So that is my reason for looking to push the trial date out a little bit in order to be able to satisfy my discovery obligations, file the motion for reciprocal discovery, and give counsel at least some reasonable amount of time to provide whatever it is they have, of which I just don't know.
All right. So while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that?
No, I think this is the only outstanding DNA issue.
Okay. So, all right. So we're not dealing with canine
No.
DNA? All right. All right. So Mr. McDermott will help us out here tomorrow. Mr. Lally will make any edits that he's suggesting to the protective order, and that will go out no later than tomorrow.
Yes.
So it sounds like, and first week of March, let's keep on them and see if we can get that DNA discovery before then. So what I'm going to do is let's keep that February 26th date. We still have the motion to dismiss and the motion for the DA's office to, let me get it right, motion for sanctions and disqualification, the DA's office.
Okay, can I be heard on that, Your Honor, please?
For heard on what? Scheduling?
On the February 26th date.
So on February, just let me finish.
Of course.
So February 26th will be on the motion to dismiss.
The motion to dismiss only?
Yes, I said we still have two outstanding. It'll be the motion to dismiss that date. And I'll hear where you're at on the motion for disqualification on that date.
I see. So I think the only issue with regard to February 26th is that's 1 week from Monday.
Right.
The Commonwealth has indicated that they anticipate filing response briefs to our motions and our memorandum. I would assert that we should be given the opportunity to file reply briefs to their response briefs. And our objection to that date is there's not enough time to get all of that done by February 26th. And the issue should be fully briefed so that both sides have had their opportunity to fully brief it, and the court has an opportunity to review the briefs prior to taking the bench on February 26th.
It's an Odell motion, right?
Well, yes, Odell, yes.
Yeah, so it's an Odell motion. I have your motion and the attachments, police reports. I have that thumb drive with all of the grand jury minutes on it. Mr. Lally, you're going to file an opposition when? Ms. McLaughlin, when is that opposition? When can we have, Mr. Lally's on trial. Can you help us out with that, Ms. McLaughlin?
Yes, Your Honor. I anticipate having one motion filed today in regards to the disqualification sanction motion.
Okay.
Probably need a few days, a week or so to get the motion to dismiss done.
Let's do it by next Wednesday. All right. And then you can have something, an opposition to an opposition or a reply to an opposition on an Odell motion. 2 days, Mr. Yannetti. You can have something by next Friday. So the hearing will be on the 26th.
Okay,
right?
what time, Judge?
Jim, what time is it scheduled? Whatever time it's already scheduled for. Okay, thank you very much.
Okay.
All right, Jim, we're done.
Great. Thank you.
Thank you, Aaron.
Football rise.
Goodbye.
There he is.